for that statute of limitations, because lawyers need time to figure out what's going on. We don't just haphazardly file lawsuits. We don't do that just because. We have to make sure that there's a case. Litigation is very expensive, and hiring experts, and really, and my firm would invest thousands of dollars in cases, as the defense invests similar amounts preparing their case. And so it's not something that any skilled attorney jumps into. So if you think you have an issue, go see an attorney if it's a workers' comp matter or a third-party negligence matter.
And is that statute of limitations based on the date of injury, or based on the time that you knew or should have done it?
Well, the question is whether or not that statute of limitations is based on the date of the injury or the time you knew or should have known that there's a claim. And again, I don't want to get into legal advice. My main point would be, if you have any concerns about that, go see an attorney immediately. But the reality is that both those standards can apply depending on the situation. Capacity is a big issue with brain injury cases. For instance, if a person is in a coma for months, do they really even understand that they have a claim? That's a question. So again, I don't want to really get into the details. I just want to let you know that those issues are there, especially with statute of limitations. It's kind of like you're sitting on a chair and you don't realize there's a rattlesnake next to you, and it's silent until it isn't. Yeah.
So is there like an organization of lawyers that specialize in brain injury, or is it just any general lawyer who takes part in
the question is it's a great question, and the question is whether or not there's whether or not essentially lawyers specialize in certain types of cases. And the answer is yes, lawyers tend to specialize in those cases.
Are there
the organizations that would get you to those specialists would be the Oregon Trial Lawyers Association. They are going to know who among their members specialize in these types of cases. The Oregon State Bar will have a similar database in their loyal referral service. Or quite frankly, you can also, because of the prominence of social media, people do tend to advertise in those areas where they know what they're doing. I'm not saying everybody that advertises that they know what's going on with a brain injury is in fact an expert. And so I guess the real answer is no, there's probably not kind of an actual hierarchy that you can just point to, but there are ways that you can assess that information. And I would also encourage people to interview those lawyers if they in fact see them with the eye of, hey, let's make sure that this person knows what they're doing.
Because maybe that could have to do with the lengthy process of trying to figure out. Yeah,
the question is whether or not that can in fact hinder the time, trying to just find someone that can help you. And there's absolutely that is absolutely the case. Fern?
What happens when you don't have any money and you can't afford to hire?
Well, look, that's a good point. I'm sorry, I'm really going slow here, but the question is what happens when you don't have any money? Well, plaintiff's attorneys in this type of personal injury case typically work on what's called a contingent basis, meaning that they get paid based on the settlement or judgment or award that's given in any particular case. So someone would come to me and they would say, hey, I had a brain injury, it was from a car accident. I would evaluate that and say, yes, you certainly do, and yes, I will take the case. But I don't get paid, if I ever get paid, I don't get paid until the end of that case. I don't charge my clients, no contingent lawyer charges their client to sit down, talk to them, and represent them in a case. It comes in at the end of the case, and that's where the contingency fee is. Typically, it's 1/3 at settlement. It might go up to, 33% at settlement. It might be 25% at settlement, depending. There's no set in stone amount. 40% if you have to litigate or if you have to go take it to trial or arbitration. And then typically there's an appeals requirement that if it has to get appealed to the Supreme Court, Court of Appeals of Oregon, the attorney fee goes up to 50%. So these are very hefty amounts, of course. Don't get me wrong, but to answer Fern's question, it gives you access. Because my goodness, my hourly rate for my hourly clients was over $300 an hour. So I'm going to come in and you know, Marta's going to come see me to try to see whether or not there's a case, and I'm going to say, well, sure, Marta, I'll do that, but give me $3,000 for 10 hours, and then we'll go from there. Absolutely not. I mean, no one would do that, and that's exactly why we have developed this contingent payment system. Workers' comp attorneys tend to be paid at the end of the case as well on a fee basis that's within the workers' comp statutes. And then other attorneys, such as Gary, will have their own payment plan. I'll let Gary address what he does with his guardian, conservator, and probate clients. I have a lot to talk about that I'm not going to get to based on the time, but I know that one of the questions I really wanted to address was, where are some resources for people who are having issues and have questions? The one that I really want to focus on is the Disability Rights Oregon, DRO. Bob Jundeff, who is the outgoing executive director of Disability Rights Oregon, he's retiring now, but he was a member of the governor's task force and just a brilliant man. They will take cases, quote, when they believe that it will cause substantial systemic changes that will improve access and service for many people. I love that. That's right off of their website. This is the good fight. This is taking a case, no cost to the individual, where that case is going to kind of move society into a better place. My note here calls it the legislation criteria. It's similar to what we did with Max's Law and Jenna's Law. We knew we had to do this to make Oregon a better state. Disability Rights Oregon does the same thing. Their phone number, and I'll just throw it out here, is 503-243-2081. Not only that, but their website has significant information about housing, about employment situations. In fact, I was going to talk about the ADA very briefly, and I am not going to have time to get into it. The ADA, though, just briefly, from 1990, recognized basically that disabled individuals were being absolutely discriminated against. Any law tends to have kind of this prologue, and in this case it's called findings and purposes. And in the case of the ADA, it's really aspirational in my mind. Findings and purposes of that law says things like this. It recognizes that disabled people have the right to fully participate in all aspects of society without discrimination, provides legal recourse to disabled Americans. It's there to remedy discrimination and segregation that include intentional exclusion, the discriminatory effects of architecture, transportation, communication, overprotective rules and policies, failure to make modifications to existing facilities and practices, talks about exclusionary qualification standards, and I'm going to close with this. I represented a young man who I really love this guy, who he's been in a wheelchair his entire life. It wasn't a brain injury, it was a birth defect, and he's in his mid-30s now. And he took a bus from Portland down to Bend. He's been in a wheelchair, as I said, for his entire life. And he took a bus down to Bend for a disabled ski conference, whatever it was. And he was out there on skis. It was one of the highlights for him. The conference ended. He got back to the bus stop in Bend. The bus driver pulled up, opened the door, looked down at my friend who's in his wheelchair, looks right straight in the eyes and says, "You're not getting on this bus."
Wow.
Whoa. What? The bus left him. The bus left him there because the driver couldn't be bothered with figuring out how to get my friend on that bus in his wheelchair. That was clearly a violation of the ADA, and by the time that I was done with that company, my friend had some additional funds to get some improvements in his life as well. The ADA is there. It's a hammer. It's a great hammer. It's for housing. It's for employment. And if we had another few hours, we could really dig deep into it. And I hope that I'll have the chance to get into it further. But with this, I'm seeing that I'm already 5 minutes over. And I really just want to thank you all for being here today. One more question.
Quick, and Gary may have that. When you talk about the insurance and the plaintiff and the one both had one, in this day and age with a few major companies representing us, if you have an accident, say, and you talk to another driver and find out you both have the same insurance company, is it safe to say they'll try to get the best for everyone, or does that put off red flags that we should talk to a lawyer or some other neutral group?
Yeah, the question is whether or not, if you get involved in a car accident and the guy who hit you has Allstate and you have Allstate, does that mean that Allstate's gonna, everybody's in the good hands of Allstate and nobody has to worry about it at all? The answer there is absolutely not. You have to treat that as if it's a separate individual. In fact, that's how Allstate treats it. They don't look at you and say, oh, you're an Allstate insured as well. They're going to just play it by the book just like they do, and any plaintiff's lawyer is going to play it by the book as well. That happens routinely, because as pointed out, you only have a handful of insurance companies for the most part. So it's very common where I will, have a farmer's insured that I represent. The defendant is farmer's insured as well. We treat that in the same adversarial light as if it were something else.
I just wanted to mention when she asked about resources, I may not be saying the right name, but the Brain Injury Connections newsletter.
Yeah.
That has a list of, I don't know if they're sanctioned, but a list of attorneys specifically for brain injury.
Yeah.
Related.
The question is whether or not there are other resources that will discuss attorneys who specialize in representing individuals with brain injuries. And Brain Injury Connections Northwest does not. So this was Brain Injury Alliance of Oregon that has a newsletter called The Headliner, which actually I've written a column for since 2005 with only one missed issue. And so, yes, there are people like us that do advertise in the Brain Injury Alliance of Oregon's newsletter.
Hi. Thank you.
Thank you.
I've been swinging lawyers for 14 months. What you have to say is very refreshing.
Okay, thank you.
My injury happened in California, so I have a whole other problem.
Okay.
What I'm wondering about is collateral damage. What's the law recognize about, let's say your spouse who has to carry this burden for 14 months, doing everything with no help,
Okay.
having to work twice as many hours. What happens to them?
Okay. The question is that there's always going to be collateral damage. There are always going to be people who are affected by your injury or the injury that occurs, and whether or not there's legal recourse for those those other people. And there is in Oregon the ability to bring what's called a loss of consortium claim.
California?
California can't comment on California, but that's certainly what you would ask your California lawyer about. I'm almost positive, of course. I think that every state would have a loss of consortium claim. Loss of consortium basically means that just what was explained. You've had to take up additional burden. Your life has been affected dramatically because your spouse has been injured this way. It is a claim that we will bring. It's not a claim that we bring routinely because oftentimes they're difficult to prove. And remember, the plaintiff always has the burden of proof. And in a negligence case, that's a preponderance of the evidence, basically a 51%. And then there's offsets for other things. But yes, the answer is yes, that collateral injury or collateral damages can be accounted for depending on the situation, and that is absolutely something you would want to ask your attorney.
Are you sure you want to stay retired?
For the time being, I really have enjoyed what I'm doing right now, and being here and being able to kind of address things on more of a policy, legislative, statewide basis. It is an absolute honor for me, and yes, I want to stay right where I'm at because I feel that I'm able to do a lot of good in more of an umbrella sense, you know, for the community at large, as opposed to, and don't get me wrong when I say this, as opposed to one person at a time. I love that work, 28 years of it, and I may go back to it at some point, but right now, doing what I'm doing, I absolutely love it. So, thank you. Is there one more question in the back? I'm sorry. One.
When somebody gets injured, is it imperative that somebody come in and take over?
That's getting into guardianships and conservatorships, and that's exactly what Gary is going to be talking about. I also want to apologize to Fern. Fern, I didn't tell you this, but I have a personal engagement that's starting at about 4 o'clock, so I have to get going now. But I just want to thank you guys very much for giving me the chance to tell my story.